and I need to set up more thing here. Video, he's here. Hold on, let me just set this up.
Cheryl, next time we do this, you really have to avoid being late. Okay? It's really unbecoming.
There's people watching.
Okay.
And they know it's not me, Steve.
Oh, yeah,
they know
exactly.
it's you. They know it's you.
Fake news. Fake news.
No, lawyers make people wait. Realtors, we have to wait for our clients.
True enough.
That's the way it rolls.
True enough.
Anyways, let's get rolling. I'm Samantha Graff Benmor. We've got Cheryl Graff, and we've got Steve Benmor as our guest from Benmor Family Law. Steve is the principal lawyer at Benmor Family Law Group, and we thought it was really important, and we recognize and acknowledge it's a sensitive issue. However, we think it's an important issue, and that issue is how to protect your children when you are helping them buy a home. So the first thing I think we should clarify, because I do believe some people are confused about this, is the difference between common law and once you're married and the rights to matrimonial home, because they are different from what I understand. So Steve, floor is yours.
So let's just jump right into this. So there's a lot of different words that are floated in society. Like we throw words like common law or matrimonial home or principal residence. All of these words are loaded words. They're defined by the legislation and by various provincial acts. So we're now dealing only with Ontario, and in the subject of real estate in Ontario, a principal residence is a word that defines a home that a person or a family occupies as their only residence. Under the Income Tax Act, a principal residence attracts no tax liability upon its sale, which, by the way, is one of the greatest driving forces to keep building and building your net worth in your home. That's not family law or divorce law. In family law, we have this other word, not principal residence. It's called the matrimonial home. The matrimonial home is defined by Section 18 of the Family Law Act to be the home that is ordinarily occupied by the spouses during marriage until the date of separation. And that's really important to understand, because they might actually have more than one matrimonial home. They could have a ski lodge, they could have a cottage, they could have a place in Florida, they could have a place in Toronto. All four can be their matrimonial home and therefore acquire the protections under Ontario family law. Whereas under the Income Tax Act, which by the way is federal, there's only one property that can be the principal residence. You cannot benefit from tax freedom on more than one property. So let's now go back to the third word that is often misused, common law. People use that word all over the world. They'll say, they are common law, or here's my common law spouse. What does that mean? Well, let's first of all define what the word common law means, and then we'll get into the common law spouse word. Common law just basically means judge-made law. That's all it means. It just means judge-made law. So the common law has evolved from the time of the UK and 1867 America Act. We came to Canada, we created a country, and here we are, 150 years later, and we've got the common law. Now, what is a common law spouse? A common law spouse is where the law has said, oh, wait a minute, they're not married. Shouldn't there be some rights afforded to that spouse who they actually never went to City Hall or to a priest or a cleric or a rabbi and got married? And so over the years, judges have afforded spouses who are living like married, but they're not actually legally married, status that allows them to acquire certain rights. And they differ from province to province. The laws regarding common law spouses in Quebec are very different than the laws here. In Ontario, a common law spouse is defined as either two spouses that have a child in common, which could be them living in two different residences. They could be two people that never share a home, but they together have a child, either by biological birth or by adoption. The other way to become a common law spouse, assuming there's no children involved, mutual children, is by residing together for a period of 3 years or more. A lot of people used to think it's 1 year, 2 years, 3 years. So assuming no children, assuming no marriage, 3 years of cohabitation, continuous cohabitation, because if, for example, they broke up for 6 months and then got back together, that's not 3 years of cohabitation. So common law spouses are different than married spouses in Ontario vis-a-vis property. Why? Because in Ontario, if you are married, by virtue of being married, you acquire rights to enjoy the rise in either spouse's net worth during the marriage. So for example, one spouse might have gotten married with zero money in the bank. The other spouse got married with a condominium. Well, then that condominium goes up by $500,000 during the marriage. It's not in the other spouse's name, but the other spouse gets to enjoy half of the rise in value just by virtue of marriage. That, by the way, can apply to an RSP or stock portfolio.
So just to clarify, it's only the increase in value that they're entitled to, as opposed to the actual whole value of the home?
Two words to that. Yes, but.
Okay.
So yes.
There's always a but.
Yes, for everything other than the matrimonial home. And this is where it gets tricky for real estate agents, real estate brokers, mortgage brokers, and quite frankly, all of society. Because if a parent says to their beloved child who is about to either get married or to buy their first home, we love you, we would like you to buy this home, we want to visit you and our grandchildren in this home, so here is $200,000 towards your deposit on that new home. And then the couple who is married lives in that home together, and they break up in that home together. Even though the $200,000 came from the daughter's parents, the husband gets half of it and gets half of the entire equity in the matrimonial home, irrespective of where it came from. And there are very rare exceptions, and they often do not apply. So the bottom line is, anybody watching this should understand that if a parent gifts money to a child, an adult child, to buy a home that becomes their matrimonial home, and that couple splits up, it's as though that gift was given to each of the two spouses, not just to one.
Okay.
Wait, hold on. What if there's a prenup? What happens?
Good. So now the question turns into, how do you protect that gift? And there are at least two very prominent ways to protect that gift. Actually, I'll list three right now. Cheryl, you just mentioned one. A prenup, which by the way is a U.S. term. We don't use that in Canada.
Called a marriage contract.
It's called in Canada a marriage contract.
Okay, marriage
different than the Americans. So that's one way that we can distinguish ourselves from our U.S. counterparts. So we call it a marriage contract, not a prenup, although everybody on the street in Canada calls it a prenup too. The other one is a cohabitation agreement. So they are living together, they might have children together, they might one day intend to marry, but they do not call it a marriage contract because they're not married and they're not planning on getting married anytime soon. So marriage contract, cohabitation agreement. Third option is to have the parents, the gifters, register a mortgage on title to the home. And therefore, you might think, well, hold on a second. Isn't that called a loan as opposed to a gift? It becomes a gift when the lender decides to not collect. So the gifter who gives the $200,000 in my example could say, here, sweetheart and son-in-law, here is the $200,000. We're registering a mortgage because we are astute, we are responsible, and we are just protecting our estate and our beloved child, who happens to be married to you, and we hope you two remain married forever. But in the event that there is a problem, we own the first $200,000 on that sale.
Do you have to collect interest on that mortgage, or it could be a mortgage free? Like,
it could be mortgage free.
It
could be all of the above. It's no different than going into CIBC and negotiating a mortgage.
It's a personal agreement.
It could be 6-month convertible. It could be a 5-year mortgage. It could be a 20-year mortgage. It could be whatever. It could have no interest. It could be forgivable. So a lot of this is just really good estate planning.
And I saw somebody asked a question. Can one, if it's only registered in one person's name, can the other person claim half of it?
Yes. So perfect example. Let's actually do 2 examples. Example number 1, wife owns a condo when they got married. Husband moved into the condo before they got married, lived there through their marriage, and then they split up while living in the condo, pre-owned by wife, well before they got married, and they lived there for 20 years or 5 years or 2 years, whatever the period is, and then they split up. By law, presumptive law, husband is entitled to half the equity, not half the growth, half the equity.
That's only for the matrimonial home.
Correct.
The home that they live in. The cottages, the place in Florida, etc. Not the same situation.
Correct.
Okay.
Example number 2.
Clarifying.
Example number 2. Husband and wife get married. They're renting, negotiating a mortgage.
It's a personal agreement.
It could be 6-month convertible. It could be a 5-year mortgage. It could be a 20-year mortgage. It could be whatever. It could have no interest. It could be forgivable. So a lot of this is just really good estate planning.
And I saw somebody asked a question. Can one, if it's only registered in one person's name, can the other person claim half of it?
Yes. So perfect example. Let's actually do 2 examples. Example number 1, wife owns a condo when they got married. Husband moved into the condo before they got married, lived there through their marriage, and then they split up while living in the condo, pre-owned by wife, well before they got married, and they lived there for 20 years or 5 years or 2 years, whatever the period is, and then they split up. By law, presumptive law, husband is entitled to half the equity, not half the growth, half the equity.
That's only for the matrimonial home.
Correct.
The home that they live in. The cottages, the place in Florida, etc. Not the same situation.
Correct.
Okay.
Example number 2.
Clarifying.
Example number 2. Husband and wife get married. They're renting at time of marriage or whatnot. Husband dips into his RSP or takes money out of his company, and he goes and he buys a $1 million condo, and he puts it in his name. And then him and his wife live there. And then they split up while living in that house. Husband had the $1 million before they got married. But because he put it in the house, wife gets half, even though the house is in. Now back to the subject of protection. There's lots of protections. The prenup, the cohabitation agreement, the marriage contract, the mortgage registration. All of those are protections. But if you do not reach into the bag of protections, automatically presumptive Ontario family law applies. Equalization of net family property. Husband gets half of that condo, wife gets half of that condo in either scenario.
So I have a scenario, I guess, like, or asking for what would be the best advice if couple's been married for 15 years. They're making a move up. The parents are no marriage contract. They don't have a marriage contract. So they've been married 15 years. They're making their move up. And one of the spouse's parents want to help with that move up. What's the best? Is it a simple contract, or is it the mortgage, taking the mortgage out at that point? Because you can't all of a sudden have a marriage contract after 15 years, or can you?
First of all, yes, you can. And some of you might know the Wallace McCain family from the McCain Foods family. Mm-hmm. And Wallace McCain, the senior in the family, decided to do an estate plan about 10 years ago. and called in all of his adult children and said, I now want all of you to go and get postnups. I want you to get marriage contracts done, another one, now 10, 20, 30 years into your marriages. So it is indeed possible to do a marriage contract after you get married. The difference, however, is there's no negotiating power on from the person that wants the protection, because once married, what if they don't sign it? Because the act of marriage unto itself is what gives the equal right. So back to your question about parents who give money later in life.
What's your best advice?
The best advice is, first of all, no shocker, every case is different. Every situation is different. You got to look at the situation, and the person should actually speak to a professional based on the individual facts of that situation. That's answer number one. Generally speaking, more protections are better than no protections. So, for example, there's the marriage contract idea. There's the mortgage idea. Those are two ideas. What's another idea? Another idea is to be the lender, to actually be the lender. So the parents, if they're gifting $200,000, well, does that mean there's no mortgage? There might be a mortgage. Well, then if the couple is going to go to the bank anyway, maybe the parents could actually be the lender. And this is where good financial planning can come into play, because the parents probably have an RSP or a RIP, in which case they are allowed to hold in their RSP and RIP mortgages. So they can actually be the lender, and they can actually collect a reasonable, below market rate of return, whereby they're helping their children, they're protecting their nest egg, and it's a win-win for everybody. So for example, if the couple would qualify for, at today's rates, a 3% mortgage, and the parents are barely getting 2% on their T-bills or their GICs, they might say, you know what, we're going to lend you that money at 2.5%. Now, 20 years later, the parents could say, we forgive the mortgage. That's okay. But that's a win-win for everybody, because the parents are getting some interest into their nest egg. The children are getting their house.
Investing that money, and
That's
they can
right.
be investing that money, and it's their choice at the end of the amortization years, or whatever the years are, that they decide whether or not they give the money back to them. And just as a little interruption here, I'm going to just let you all know that a couple of days on a financial planner, Jackie Porter, next Tuesday on our talks, and we're going to be discussing, we're kind of continuing with this theme of helping your kids and the best
And actually,
ideas.
Jackie Porter is a really good expert on the subject, because she actually is the financial advisor that is in between the gifting parents and the receiving spouses.
Yeah.
And she's a financial advisor who really has a real understanding of divorce.
Yeah, she's excellent. So we're looking forward. I'll be speaking and doing our little trailer film later today.
If somebody is going to so-called put the mortgage on their children's home, but they can't give, the full amount that they need to borrow to buy the home, so it has to be registered on title as a mortgage, but that's an interest-free, if that's the way they want to do it, or at a very low percentage.
Now, just once we get into the weeds, if the parents are lending, I'm making this up, $200,000, they might say that it's $200,000 plus 3% per annum, payable at the termination at the mortgage. Why is that relevant? Because if they actually later choose to enforce it, for example, because the couple splits up, then why not enforce not just the principal, but the gain? Because remember, the couple probably, by the time they split up, would have already enjoyed some gain on the property anyway. So why shouldn't the parents be able to collect back 200 plus some version of the gain? Because 2% or 3% is probably going to be lower than what the couple is gaining tax-free on the sale of their home later.
Okay. Good.
Are there any, do you want to take a little quick second to read if there's any questions on the feed? Because you can only see them, I think.
So while you're looking at the feed, I'll just continue down this road and say
If I knew how to do that, it would be good, Samantha. But the only thing I saw was the one question that asked about the, can you see
One
it?
person was,
Yeah,
now
I
I
saw it,
realize
yeah.
I can.
I think
Right,
we passed
there was
that
only the one question, and I
Yes,
had
it was
asked-
from James. Hi, James.
Yeah.
So,
We love James.
you know, to follow along this concept, some people are really, really smart and very strategic. So, for example, the person that owned the house when they got married will keep the house, but they will move elsewhere so as to not allow the first home to be considered the matrimonial home. Because remember the definition? They had to have lived there on the date of separation. So, if they moved into, upon marriage, one of their houses, but then during the marriage they moved elsewhere, but they kept the person that owned it kept the first house, then the only thing that owner shares is the growth, not the original base. So if that condo was worth $1 million and during the marriage it grew to 1.3, then they only owe $150,000, not $650,000. So that's just by virtue of, forget prenups, forget mortgages, they just moved out of that house and they went elsewhere, rented, bought, whatever. And what I tell a lot of clients in this situation is, as much as you can, go equal.
Because you don't turn it off.
So for example, if you're gonna buy a new home, try your best to make equal contributions into that home. That could include, by the way, gifts from the family. And that way, even though it's a gift from one side, it equalizes the money going in. So it's not unreasonable if the gifter, they put in 200 and the other person pulls out of their RSPs or cash or whatnot 200, they're each putting in 200. No marriage contract, no prenup, no mortgage, but at least that's reasonable because if they break up and sell, they each put in 200. One came from the family, one came from investments.
So if somebody, and this might go into a little bit, and we're actually going to be bringing like an estate and real estate will sort of lawyer on, but and this might go into that, so I apologize in advance if this is the wrong area, but when you're talking about inheritance, I remember we were talking one time and there was a situation where somebody who was maybe in a little bit shaky of a relationship, shall we say, the one advice that I remember you mentioning, so you can maybe clarify a little bit more on this, is that if the money from an inheritance goes into the matrimonial home, that just with no marriage contract, that goes back to exactly what we were discussing, in that the spouse who is not related to the parents, like,
I understand. So the short answer is, we're getting into another area, but I'll answer it very quickly. A gift to one spouse during marriage, whether it's by way of an inheritance or just a present, treated the same way, generally speaking, is not shared upon separation. So the parents who say to the child, I'm giving you an early inheritance, here's $200,000. If that spouse takes that money and puts it into a GIC, puts it in an RSP, buys another condo as an investment, they are protecting that money. If they were to break up, the other spouse does not get a piece of that.
even if there's not a marriage contract.
Correct. However, they took the 200 and they renovated the kitchen on the matrimonial home, or they paid down the mortgage. Then that was like gifting the money to the other spouse.
Because it went into the matrimonial home. Now, if they put that into their cottage or their condo in Florida or Mexico or where not otherwise, is it the same?
Yes, remember
only
what
the
I said.
matrimonial home.
You can have multiple matrimonial homes. So if they took that 200,000 and said, hey, let's buy a cottage with that. and let's put it in the name of the person who got it from their parents. Still a matrimonial home? It still is shared.
So the only way to protect early inheritance, using your verbiage, is to put it in an investment. Does it
or
have to
put it
be
another way? Just don't put it in a matrimonial home. That's the best way to say it. Just don't put it in a matrimonial home. And when I say put it in, I don't mean put it in a shoebox on the shelf. I mean like don't put it in the mortgage, don't put it in the deposit, don't put it in a renovation. Don't have anything to do with a matrimonial home, because once it touches it, it becomes a joint asset.
So just to wrap it up, I would say that just to clarify on if a couple is deciding to buy a second or a third property other than the matrimonial home that they live in, would you recommend them having, I guess it's called a post?
Yes, in the U.S. a post-nup, a marriage contract.
A marriage contract at that level in their marriage to just say, hey, you know what, this money came from my parents and I'm going to buy a small condo here and I would like to therefore put it in my name and it be mine and, you know,
right.
Have a contract.
So just like everybody who's watching knows they should have a will, not everybody who's watching has a will. I mean, we all know what we should do and what we do. So on the subject of people get money, whether it's from a gift or from an investment that paid off, many people have this tendency, it's psychological, to want to pay down debt. So even though it's their main debt usually is their matrimonial home mortgage, or for example, a renovation loan, their inclination is, oh, new money came in, pay down debt. It's a very natural impulse. It's all over the world. However, very few people are thinking, family law. I actually am paying off half of her debt or half of his debt when I do that. Or worse than that, my parents are paying off half of his debt when we do that. And so what they need to do is pause for a second and get some advice from people like either myself, yourself, Jackie Porter, people that are in the know on how to best protect that money. Because the $200,000 that we keep referring to as the example, that $200,000 did not just fall out of the sky. Those parents worked really hard during their life to create that wealth that would allow them to give that money. And when the divorce rate is at 50% and the rate of breakup in common law relationships is even higher, the likelihood that that $200,000 is going out the door is very high. That's not a rate that you want to challenge by good hope and prayers. So protecting that gift is really critical, no different than getting a will done to make sure that everybody is protected, including, by the way, the recipient.
I think Steve put it best, and we'll probably close off on this note, that as sensitive a matter as this is it's the responsible thing to do. And I remember hearing Steve say this plenty of times with marriage contracts that I've heard him do. He says that, you know, we're going to type it all up. We're going to protect, you know, what is yours and what your parents have helped or you have yourself made. And we're going to put it in a closet and we're never going to look at it again. But it is the responsible thing to do. No different than the will. You know, nobody wants to think about these things, but at the end of the day, it could happen and we put it away and hopefully we never take it out.
And if I could give a plug, there is a company called spliteasy.ca and they make available cohabitation agreements and marriage contracts at online at a very reasonable price. And so that's a way that real estate lawyers and agents are able to access easy, affordable contracts to protect their relationships.
Steve, I want to say thank you. Thank you, Samantha. Next time I see you, likely you'll be on time, Mr. Benmor. Thank you.
Thanks, everyone. And
Thank
by
you.
the way, feel free to send us, either Steve or Cheryl or myself, any questions that you might have. We're happy to help out any way we can. And